Mr. Upper.
My Lord, my Lady, I appear on behalf of the appellants with Mr. Crilly, my own friend Mr. Brown, King's Counsel, appears on behalf of the claimant respondent. Before we begin, can I start by dealing with housekeeping, just in terms of the bundles with which you have been provided?
Yes.
Before you arrived, I think there was some organisation of the paperwork. What you should have is as follows: a slim volume core bundle, which was submitted at the permission to appeal stage.
Yes.
That was followed by a larger supplemental bundle, which on our side incorporated the documents we considered necessary for the appeal.
Yes.
There then followed from that, on the respondent's application, a supplemental bundle, which was the transcripts of all of the factual witnesses.
Yes.
And at the front of that bundle, you should find a supplemental skeleton from the respondent, which either adds to or deals with issues different to what was in the respondent's skeleton argument when the respondent was skeleton. So although it's really the bundle evidentially is the transcripts bundle, it has within it at the start that second skeleton argument.
Yep.
There then followed, probably as a reflection of breakdown in communication and nothing else, the respondents put in a slim collection of authorities, I think 3 in total. We did the same on our side. Thankfully, there's no duplication of those authorities. There's a collection of a total of 6. It's just unfortunate we hadn't put them into a single volume for you. I don't know whether my Lord, it appears to be working electronically. But the electronic
Well, as far as I'm concerned, it's all there.
Yeah. Good, I'm grateful. Thank you. So this appeal arises out of a road traffic accident which occurred on the 11th of August 2019. On that date, the first defendant was pulling out of Hardwick Court, a side road in a completely normal and usual residential area. She was emerging in order to turn right onto Ackworth Road and Main Road. The speed limit on Ackworth Road was 30 miles an hour. The judge found as fact that the first defendant looked first to her right, then to her left, and then to her right again before emerging. The judge also found that she correctly assessed that it was safe for her to pull out at that time, and in particular, there was no traffic coming towards her from her left, the direction that ultimately the claimant came from as he rounded the bend to approach Hardwick Court. She proceeded to pull out, and she did so, as described by the witnesses and found by the judge, in a completely normal fashion. To the left of Hardwick Court, as my lords and my lady will have seen from the photographs, is what's described as a sweeping right-hand bend. It's a sweeping right-hand bend for traffic travelling in the direction of, as Mr. Raspin was, coming towards Hardwick Court on the right. Visibility for the first defendant to her left, a key issue in the case, towards the bend, the judge found, on the basis of the evidence of Dr. Walsh, an accident reconstruction expert, was 68 to 74 metres, effectively measuring near side towards far side, there being a slightly longer range of view towards the far side of the road than the near side. As the claimant was executing her right turn, the first defendant was executing her right turn, the claimant rounded that right-hand bend, travelling, as the judge found, in the low 50s miles per hour. That was far in excess, as he said, of the 30 mile an hour speed limit on Ackworth Road. As the first defendant came around the bend, he was confronted by the first defendant's vehicle as she was out into the road, partway through executing her right turn manoeuvre. The claimant applied emergency braking, causing his motorcycle to skid with the wheels locking up. He lost control of the motorcycle, which capsized and went to ground. He and the motorcycle slid along the ground before striking the first defendant's vehicle, being thrown towards the curb, striking the curb, and then deflecting to continue down the road. At some point in that process, the claimant became separated from his motorcycle and sadly suffered life-changing injuries. At trial, the claimant's primary case was that he was doing no more than 30 miles an hour. He was in view and there to be seen when the first defendant looked to her left. and when she pulled out. That case was rejected by the judge, who found, as already stated, that the claimant was in fact travelling in the low 50 miles per hour and was out of sight when the first defendant looked to her left and when she commenced her manoeuvre. There is no cross appeal against the judge's rejection of the claimant's primary case. The claimant's secondary case was that the first defendant was under a duty to look to her left a second time when she was in the process of pulling out. Although it was never put to her that she should have looked left a second time, or when she should have done so, and although no evidence was ever led by the claimant as to when the first defendant should have looked left, and no submissions were made on that issue, the judge found that the claimant was under a duty to look left again during the course of her manoeuvre. He further found that had she done so, she would have seen the claimant and the accident simply would not have happened. On the issue of contributory fault, you've seen that the judge reduced the damages award for the claimant by 45% to reflect the blameworthiness and causative potency of his speeding. Inexplicably, notwithstanding his finding that the claimant was partly responsible for the accident and to the tune of 45%, he dismissed the defendant's counterclaim. The reason given for the judge for dismissing the counterclaim was because he considered the primary cause of the accident was the first defendant's failure to look left. And we'll come on to that under ground 4 of the appeal. That fundamental error was obvious to both parties, and by consent, the claimant agreed to judgment on the counterclaim being entered in the defendant's favour to the extent of 45% recovery. The judge acknowledged that consent, and in a very short supplemental judgment in your bundle that we will come to during the course of submissions, for your note it's at core bundle 105, the judge acknowledged the agreement that that was an error, gave no explanation for his error, and simply approved the consent order as part of the overall order following his judgment. It's against that backdrop that the defendants now appeal the judge's finding of primary liability, first of all on the issue of the existence of the duty to look left and the terms of any such duty to look left a second time, and second on the issue of causation. Subject to the views of my lord and my lady, my proposal is to deal with some of the key findings and factual issues and evidence to set a context for how we say to approach the appeal and those essential issues that the judge had to look at before then turning to the grounds and taking them in sequence 1, 2 and 3 together because they both relate to the issue of causation, 3 following on from our criticisms under 2, and then finally to come to ground 4.
Thank you very much. Now, I'm sure that you and Mr. Brown will have discussed timings. Where have you got to?
I think my assumption would mean that if I had the morning, Melinda Friend had the afternoon.
Well, that sounds like a bit of reverse engineering, or the application of Parkinson's law. So I think we probably feel that that we might move more quickly than that.
Well, I understood.
But obviously, everything that needs to be said must be said. But I imagine we can probably expect that you'll be finished fairly considerably before lunch, and that Mr. Brown will be on his feet before.
I will not be as long as Mr. Allen. So.
No. Well, as I say, we're in your hands. The day is theoretically yours, but we have a sense of the issues that arise on this appeal, and as you, I hope, find, we've read everything that you've given us with care.
Right, I'm grateful. Well, therefore, on the judge's primary findings of fact, we can take those very quickly. On this day, the 30 miles an hour limit was not operating as an inhibitor for Mr. Raspin. And these come from para 94 of the judgment.
Yes, we won't need to follow you through the judgment. Just give us the paragraph numbers as you progress.
I'm grateful, my lord. So para 94, CCTV footage showed him at 52 miles an hour, a short distance before he approached the bend in the collision site. para 94. He found that as he approached the collision, he was travelling, quotes, in the low 50s, para 95. We've already touched on the visibility distance. We've already touched on his acceptance that Mrs. Taylor looked right, then left, then right again before pulling out. And we've also confirmed that when she looked to her left, the judge found when she looked and when she moved out, Mr. Raspin was not in view. The distance travelled...
What's the paragraph for that?
Paragraph 95, my lord. Para 95, core bundle page 90. Core bundle page 95.
But don't worry, we've got the judgment, as long as we know the paragraph number.
Yes.
It's not 95.
96. End of paragraph 96, CB 95. The distance travelled by Mrs. Taylor to the point of collision was 10.4 metres, para 96. And it took her approximately 5 seconds to travel that distance. Again, para 96. Had Mrs. Taylor looked to her left again when she was 2 seconds into her manoeuvre, then she would have been able to see Mr. Raspin, para 102. One of the points my learned friend makes, I believe in his second skeleton argument, is that Lord Justice Stuart Smith was wrong when he made the observation as to the distance that would have been travelled by a vehicle travelling at a constant speed of 52 miles an hour, which was effectively Dr. Walsh's evidence and the evidence accepted by the judge. And my learned friend says that misapprehension or misunderstanding influenced the grant of permission appeal and influences the issues that we have to look at. It is clear that the judge found, insofar as it's of importance, that Mr. Raspin was travelling at a constant low 50s miles an hour prior to, through, the bend and to the point of collision. The reason we say that is Dr. Walsh's evidence, which the judge accepted, was that if the claimant was travelling at a constant speed in the low 50s, he would have been out of sight when Mrs. Taylor looked left and started her manoeuvre. The only basis upon which the judge could find, as he clearly did, that Mr. Raspin was out of sight at those 2 stages was if he accepted that Mr. Raspin was travelling at a constant speed in the low 50s. So insofar as there's a faint suggestion that what the judge actually found was that there was initially 52 on the CCTV, then deceleration, then acceleration, and that has any bearing, that's not what the judge found. And when one looks at the judgment, one can see that. The reference for Walsh, where he makes the point that the claimant would be out of sight if travelling at a constant speed in the low 50s, it's Walsh, paragraph 91, in the supplemental bundle, page 59, Walsh, para 129, in the supplemental bundle, page 69, and then in the joint statement of the experts, paras 4.46 to 4.48 in supplemental bundle, page 182.
Mr. Allen, I'm sure the fault is mine, but if one looks at paragraphs, it's just your point that the judge found the claimant was travelling at a constant speed.
Yes.
At 94, he says he was riding at 52 miles an hour, a short distance before the collision.
Yes.
And he says that doesn't mean he was or was not riding in that speed as he immediately approached. Yep.
Yes. Yes.
He says, as you've told us, that the speed limit wasn't an inhibiting factor on him. And then he says, in making a finding regarding the claimant's speed, mindful of accident reconstruction, based on the analysis, I conclude that the claimant was travelling in the low 50s. But please tell me if I'm missing something here. That final sentence, he concludes he was travelling in the low 50s. Is that what you're relying on as to the constant speed or something else?
No, there's 2 points, my lady. First of all, paragraph 94,
Yeah.
all that the judge says there is, we know from the CCTV and what was agreed by the experts what speed, it was approximately 300 metres before the point of impact the claimant was doing. That of itself doesn't tell one what speed he was doing during negotiating the bend or at the other side. What the accident reconstruction experts, Dr. Walsh, was able to tell the judge, working back from the physical evidence at the scene, the marks and so on, was that his speed immediately prior to emergency braking was in the low 50s.
So although the judge doesn't say it, that's in fact what he meant, is it?
Oh, it is, my lady, because when he goes on to look at, for example, the questions of contributory fault, it's on the basis that the claimant is travelling in the low 50s miles per hour. That's his finding as to the level of speed of the claimant before and immediately before the collision. And that's the speed that the experts analysed from the hard evidence, was what was his speed immediately prior to emergency braking. That's what they were able to tell, and that was the limit of the expert evidence and the experts could provide. In terms of why that was a constant speed, and I can take to the passages if necessary, the judge found as a fact, and there's no challenge to this, that when Mrs. Taylor looked left at first and then pulled out, the claimant was not in her view. That was her evidence, that she looked left and didn't see him. The judge accepted that and made that finding. That finding is only consistent with the claimant travelling at a constant 50 miles an hour, at low 50s, before, during and after the bend.
So that's how you extrapolate what the judge doesn't say.
It has to be his finding based upon his conclusion as to speed and the fact that the claimant wasn't in view when she looked left. And in terms of speed, I said to my lady that yes. If we turn to page 110 in the judgment, please. Core bundle, page 100. In terms of the clarity of his finding as to speed, it scarcely needs saying that 52 miles per hour or thereabouts is plainly excessive speed in an urban area with a challenging road layout. And then he goes on. The only challenging element of this road layout was the bend. But in terms of the claimant would only be culpable in terms of contributory fault and being a cause of the accident if his speed as he approached the accident scene was 52 miles an hour, as the judge found, or the low 50s, as he characterised it earlier in his judgment.
Of all the findings that you've been taking us to, are you right to understand the crucial one as being the one at the end of 96?
On the findings of fact?
Yes.
Yes.
But from your point of view, that's critical.
Well, no, that on the primary case, that was the critical. In terms of determining that the claimant was travelling at a constant speed, you marry that with the judge's findings. He could only not be in sight if travelling at a constant low 50s. But it's not, that finding isn't critical for this appeal. It simply deals with the primary case, against which there's no appeal, but it helps us understand the finding as to the continuous speed. A second point, which we can take quickly, Mrs. Taylor has always accepted that she didn't look left for a second time and didn't see Mr. Raspin at any point prior to impact. The respondent covers and repeats time and again the significance of the evidence of the lay witnesses who saw her car emerging and continue to pull out at a point when Mr. Raspin had come round the bend into view. She conceded at the scene in the reaction to say I hadn't seen him. She confirmed that in a police interview, and she'd never claimed to have looked left before. So in terms of the necessity to trawl the factual witness evidence to make that point, we accepted it before the trial judge. That was a finding that he made, and we proceed on this appeal on that basis. In terms of stopping distance and perception reaction time, which both elements that Lord Justice Stuart Smith identified as, in his view, critical considerations or questions with which we agree, the judge made no findings at all as to what Mrs. Taylor's perception reaction time was in fact in the actual happening of the accident, or more importantly, what it should have been had she looked left for a second occasion. We highlight that for, as you've seen in our skeleton argument, one of the points that we pursue is the absence of that finding and others on causation undermine the learned judge's approach. But my learned friend says in his supplemental skeleton argument that at paragraph 102 of the judgment we can see the judge look at the issue of perception reaction time and presumably make findings, and then further he revisits it at paragraph 107. Again, to give context to the arguments that are going to follow, can we turn to paragraph 102, please? Core bundle 97. If I invite the Lord and the Lady just to read 102 or remind themselves of the content of 102.
Yes.
There's no reference anywhere in that passage to perception reaction time generally for Mrs. Taylor or in the particular circumstances of the but-for scenario. If, as she is in the process of pulling out and looks to her left and sees Mr. Raspin, what time would it have taken her to assess his speed, determine that it was an abnormally high speed, and then decide to make a response? The only reference to time there, in terms of time and distance, is the 3.06 seconds to cover 71 metres. That's just a bare calculation based upon, I think, 52 miles an hour equates to 23.6 metres per second. A car travelling or a vehicle travelling at 52 miles per hour will in fact cover 71 metres in 3.06 seconds. That is not a reference to how long it would take to decelerate from 52 miles per hour or otherwise. There's no analysis or reference to perception reaction time anywhere in that paragraph. And at 107, staying with the theme of perception reaction time, and where my learned friend says we can find how the judge dealt with it, he refers to paragraph 107, core bundle 99. In a much shorter paragraph, he simply refers to what the stopping distance would be for a motorcycle travelling at about 30 miles an hour. The 1 second or 1.5 second fall within the range of illustrative reaction times given to the judge by the experts as a matter of generality. There's literature as to that in normal driving conditions, perception reaction times tend to fall within that range, the median in the 1 to 1.5 second range. But there was no finding or consideration there of what Mrs. Taylor's perception reaction time would have been when she would have been in very different circumstances. So in our submission, contrary to what my learned friend suggests, and we'll listen to what he has to say, there was no analysis at all of the judge and no finding of what the perception reaction time for Mrs. Taylor was or should have been, and in fact he makes clear that that was unknown. He specifically states at paragraph 101, those times are in his judgment unknown. 101, page 97, where, 3 lines down, where in the course of her 5-second exit the claimant ought to have looked left again depends upon her perception and response time, which is unknown and was for her to determine. And for your note, the judge makes the very same point when refusing himself permission to appeal, page 107 in the core bundle, when he says, one cannot know D1's reaction time nor the effectiveness of her braking response. So not only does he not make any findings, as my little friend seems to suggest, he specifically says those are not known and are not capable on the evidence of making a finding in his view. Page 107. So, against that backdrop of giving some context to some of the key issues, the findings made, not made by the judge, and the evidence that was before him, can I turn to ground one? This is the question of whether the first defendant was under a duty to look to her left for a second time, and in particular, what the obligation or what the demand of that duty was. There are 6 points we make here, which will develop, but to give you the 6. First, we say the judge fell into the very trap identified in Lambert and Clayton and Ahanonu of elevating what might have been done that could possibly have avoided the accident into a duty to take those actions. Second, the question of reasonable foreseeability. What was reasonably foreseeable for the first defendant? Three, to look at the judge's acceptance that as a generality there wasn't a duty on a driver pulling out from the side road to look left for a second time. Such a duty depended upon the circumstances. 4, the duty to look right, flowing from the authorities the respondent refers to. 5, again, we say this is an error that the judge made, that the duty to give precedence to traffic on the main road is not a duty to ensure that there is complete, unimpeded road space for any vehicle, particularly a vehicle travelling at very high speed. And then 6, to look at the issue of gap acceptance theory, evidence given by Dr. Walsh, accepted by the judge. So point number 1, we say the judge elevated what could have been done to potentially avoid the accident to a duty to do so. And can I take my lords and my lady to paragraph 99, please, starting at core bundle page 95. It's in paragraph 99 that the judge analyses and reaches his conclusions on breach of duty, on the existence of duty and therefore breach.
Yes.
On page 96, if your hole punches are the same as mine, midway between the hole punches, you should see a sentence that starts, however. However, in the particular circumstances and layout of the it should assumably the road emerging from Hardwick Court with visibility restricted by the bend, for a driver to put themselves in a position where they could meet their continuing obligation to give way, even to a driver approaching at around the speed limit for the road, did, in my judgment, require an emerging driver to look left again in the course of their manoeuvre. So pausing there, the duty that the judge finds when analysing breach of duty from almost that prospective perspective, the high point of it is a duty to look left again at some point during the course of the manoeuvre. At paragraph 100, as we see from the first sentence, the judge goes on to deal with the question of causation. So he's dealt with duty, he's defined the duty there, the duty on the emerging driver to look left again in the course of their manoeuvre. That duty could be discharged looking at 1 second or at 4 seconds. At some point during the execution of the right turn, if the duty is to look to the left at some point, there were variables as to when a reasonably prudent driver would look to his, her or their left.
Why do you say that? And presumably if you're looking left a second time, you look left at whatever the time is that's going to give you the information that you need. It'll be dependent upon the precise manoeuvre that you're undertaking.
Yes, but then in terms
so, for instance, it's not likely to be sensible if you've looked right, left, and right, then to look left immediately as you begin your first metre of exit from the side road.
No, agreed.
You're going to instinctively look, if you're going to look at all, at the point where it's going to give you the useful information.
Yes, but in terms of when that is something that has to be balanced and seen in the context of there's a duty to pay attention to traffic that's coming from the right, which is where you present the gravest danger in the early phase of your manoeuvre, or the greatest danger. Yeah. And then there is the need to pay attention to what is ahead of you. So in terms of when that point is, I take the Lord's point that it can't be immediately, but in terms of when it arises, it is, that doesn't form part of the judge's analysis of what the duty is at that stage. It's when we come to causation at 100 and he's analysing causation, that is when he refines and revises what he says was the duty. We say that's important because that's the very error of assimilating, trying to frame what the duty is in a particular case by reference to the judge's analysis of causation. When he's looking at what might have made a difference here and the possibility of what steps would have been needed to have any chance of avoiding the accident, once he's identified those, he then takes that back to say, well, that was the duty. If what needed to be done here in order to avoid this accident was potentially was X, Y, and Z, he then says the first defendant was under a duty to look to her left at a point at which she would have been able to execute X, Y, and Z. It's identifying what, as a matter of causation, could have been done to potentially make a difference and elevating that into a duty, we say. So, for example, at paragraph 100, on page 97, it's 6 lines up from the bottom. In the hypothetical situation with which we are now concerned, if when pulling out the defendant were to have seen the motorcycle heading southbound at speed, emergency braking would have been needed and her stopping distance would likely have been much shorter. So he identifies what steps would have been necessary in order for Mrs. Taylor to have any chance of avoiding the impact. And at the bottom of 96, second line down on para 100, the time to look left to guard against a vehicle having come into view when the road had previously correctly been perceived as clear may be put at when, by effecting an emergency application of the brakes, one could avoid encroaching substantially into the lane on the main road into which one was turning, brackets the unexpected oncoming vehicle which should have priority might be a car rather than a motorcycle. That point was something for the defendant to judge with knowledge of the speed at which she was travelling, the capabilities of her vehicle and her awareness of her own driving capabilities. So the duty, and my Lord says, well, legitimately, it has to be at a point at which it will provide you with some useful information, but the judge doesn't even frame it by that. What he says the duty upon every reasonable driver emerging from Hardwick Court was to identify the point at which, by the application of emergency braking, making due allowance for her own likely perception time and likely stopping distance, by looking left and securing the information that she needed about the oncoming vehicle, she would be able to stop without encroaching into the far lane by the application of emergency braking. In our submission, that is an artificial duty. The expectations of it for the ordinary reasonable motorist are unrealistic.
But simplifying this a little, and to give you the opportunity to explain why this is a wrong way of looking at it. Effectively, the reason why you were found to be responsible for the accident is because you didn't look when entering another carriageway in order to see a vehicle that was there to be seen.
Well, on the judge's findings, the 2-second point, we're not in the process of entering another carriageway. It's a much earlier stage than that.
Well, you were in the main road. You had entered the main road, and the judge found you to be responsible for the accident because you didn't look to see a vehicle, look in order to see a vehicle that was there to be seen.
Yes. He found that was our breach of duty.
Yes. So what's wrong with that? If the vehicle is there to be seen, I mean, forgetting for the moment that questions of speed and contrib and so forth, but if the vehicle is there to be seen, what is one doing entering a main road and not seeing a vehicle that's there to be seen? Isn't that the gist of the judge's finding against you?
To an extent, but it's in the context of, as Heaton and Herzog and the other authorities identify, there is a duty on the emerging driver to continue to observe to her right. So at the time that she's pulling out, her duty is to pay attention for oncoming traffic there to whom she represents the immediate and greatest danger. She has to navigate her turn, and there are other things for her to look at. On my Lord's point, it would follow that there is an absolute duty on every emerging driver.
I mean, we've all seen what this road looks like. It's a tricky main road, in the sense it's not in open countryside with sweeping views in all directions and so forth. It's a suburban, quite confined main road with a very large number of junctions coming in and both sides and so forth. But so in those circumstances, the gist of the decision against you seems to have been that a driver entering onto a main road of that sort ought to make themselves aware of vehicles that are there to be seen. Of course, there comes a point where a person's speed is so extremely excessive that they've deprived you of the opportunity of seeing them, but that's a different...
But the question of speed brings us on to the question of reasonable foreseeability and the question of gap acceptance.
Well, the judge found that, unfortunately, it's not... I mean, the judge was prepared to accept that, unfortunately, people do speed on roads of this sort, and that's part of the hazards of driving.
Agreed, but what the judge accepted was our submission that it wasn't reasonably foreseeable that somebody would be travelling at the speed that Mr. Raspin was. At paragraph 99, 1, 2, 3, 4, on page 96, I think it's seven lines down. The driver emerging onto a main road has a continuing obligation to give way. Mr. Allen accepts.
Sorry, I'm with you now. Okay.
Sorry, I'll start again.
I've got
7 lines down. The driver emerging onto a main road has a continuing obligation to give way. Mr. Allen accepts, correctly in my view, that a driver exercising reasonable skill and care is under a duty to anticipate some degree of failure to comply with the highway code on the part of the other road users, albeit not the degree of failure represented by the speed at which he invites me to conclude the claimant was travelling. The speed at which we invited the judge to conclude he was travelling is exactly the speed that the judge found it to be. Dr. Walsh's evidence as to a average of 52 miles per hour within the normal distribution.
Sorry to interrupt. Are we now on point 2?
We've moved to point 2, yes, my lord. Sorry, it was
Thank you.
Responding to my lord's...
No, I just want to make sure I've got
We're on point 2 about reasonable foreseeability. So the judge accepted that it was reasonably foreseeable of some degree of speeding, departure from the 30 miles an hour, query 35, query whether as much as 40. But he accepted our submission that it was not reasonably foreseeable, and the reasonable standard of care did not require Mrs. Taylor to anticipate the possibility that somebody would come around that bend in the low 50s. Sorry, Lord.
No, I just don't want to miss this point. Where do you say that statement is anchored?
Sorry. It's paragraph 99, my lord. Core bundle, assuming your electronic page.
Yes, well, of course.
It's bottom right-hand corner, 96.
Where it says Mr. Allen QC accepts. It's sort of 5 or 6 lines from that point.
Yes, I was just trying to see whether that was in fact a finding or simply a partial a recitation and partial acceptance of your submission.
Well, I take it from Mr. Allen accepts, and then the judge says correctly, in my view.
Yes, well, I don't myself at the moment. I need to think harder about it before doing so. Accept that the bracketed paragraph of that sentence represents a finding by the judge that it was not foreseeable that people would be driving like this claimant was driving.
If that's the view my lord reaches, or the court reaches.
I mean, it's simply for a finding of that importance. One would expect it to be made in a direct way and not in an arguable and oblique manner. Anyhow, I was obstructing you just to say that you shouldn't assume, at least as far as I'm concerned, that the judgment contains a finding that it wasn't foreseeable that somebody would be driving like this cyclist was driving.
You have our submission as to what's said at paragraph 9.
Exactly, I understand that.
Grateful. I understand. And if there's anything else that can make that point, then we'll highlight it for you.
Thank you.
So, and to follow that to its logical conclusion, and this isn't trying to frustrate you, if we are right on that, then that feeds into why does the duty to look left for a second time arise when, on the judge's findings, for a car travelling in the 30 miles an hour at a speed above the speed limit, but in those 30s...
Well, of course, there's no duty to look left for unforeseeable events.
My lord has the point.
So that rather fortifies my view that that's not what the judge was finding.
Point number 3, the judge's acceptance that the duty to look left was not absolute and depended upon the circumstances. The point we make there is that there was nothing peculiar or unusual about this particular junction. As my lord had observed, it's a completely normal junction in an ordinary residential area. And visibility was comparable in both directions. In terms of balancing the view one way and the primacy of the duty to look right, which we'll come to, the judge found that the distance was, the sight line to the left was 68 to 74 metres. That was from Dr. Walsh. Dr. Walsh didn't measure the sight line to the right. The only expert who measured the sight line in both directions was Mr. Taylor, the claimant's expert. He had it at 80 to the left and 90 to the right. Visibility to the right was limited as a result of the crest of a hill. Traffic was travelling uphill and would be out of sight. So in circumstances where there is comparable visibility to the right, same visibility or similar to the left, that as you're pulling out you have, you represent the greatest threat or the immediate threat to traffic coming from your right. And as we'll come on to, the primacy on the authorities afforded to continuing to maintain an observation to the right as you are emerging, we say there was nothing peculiar or unusual or sufficient in the layout here to demand that there was a duty to look left a second time. That takes us then to point 5 on duty, the existence and the primacy of the duty to look right.
Sorry, that's point 4 actually.
Sorry, you're right, my lord. Point 4, the primacy of the duty to look right.
I'm sorry it has been, but I'm trying to make a note of this for later purposes.
Understood. The duty to look right the respondent relies upon Heaton and Herzog to establish that a driver emerging and effecting a right turn under a duty to give way to traffic on the main road is under a duty, what Heaton establishes is a duty to maintain a continuous look to the right as they are emerging. That was considered and approved by this court in Armsden and Kent Police, and is well established that for a motorist effecting this manoeuvre, the primary duty is to maintain that view to the right. We don't say that that means there cannot be, in appropriate circumstances, a duty to look left as you are emerging, but any argument or the suggestion that there is such a duty in our submission has to be analysed with some caution against the backdrop of the primary duty that Heaton, Armsden and the cases before, I think it's Dolby and Miller, which the respondent refers to and is referred to in Heaton, all establish. In our submission, married with the other factors, but in particular layout and visibility to the right, we say where the primary duty on the claimant is to, on the first defendant, is to maintain her view right, and balanced with the reality of executing her manoeuvre, it is a step too far to say she was simultaneously under a duty to look to her left for oncoming traffic. The judge equated the duty to give precedence to traffic on a main road to being a duty to afford that traffic no interruption and to create no potential obstruction for traffic coming into view. Effectively, a duty to ensure that the main road was kept free for all oncoming traffic, which we say is not the duty that a reasonable motorist owes. Can I take my lords and my lady to Lambert and Clayton, please? This is in our authorities bundle.
I'm very sorry. Where does he say that?
Sorry?
Where does the judge equate the duty to the traffic on the main road with a duty to keep?
That's what we say the judge has done. The judge didn't say...
He didn't say that.
No.
You're just saying that's
what it amounts to.
That's what you must infer from the overall, the entirety of his judgment.
Yes, but...
Yeah, all right. No, sorry, I just wondered if there was some passage there.
Well, what the judge refers to is the duty to give way. What he's found is, with a duty to look left a second time partway through, and having defined that duty as we've looked at already, as looking at a point at which you could react by the application of emergency braking and so forth, in effect the duty is that as you are emerging, you're under a duty to make a check which would allow you, even for a vehicle travelling at this speed, to allow that far lane to be unobstructed and to allow unimpeded traffic flow for anybody coming round the bend at whatever speed. We say that's too high. It's not negligent for a driver who has made proper checks before pulling out to pull out into traffic and to create an impediment or cause oncoming traffic to have to slow down to allow them to join the traffic flow. We take that from Lambert and Clayton. It's in our authorities bundle. If you should have a paginated bundle. It's authority number 1 and it starts at page number 5. by way of introduction or reminder, Lambert and Clayton was the situation of a vehicle, a longer vehicle on a main road, effecting a right turn into a side road. So it wasn't a car emerging from a side road, and we don't take you to it for its factual equivalence, but it was a car on the main road, turning right into a side road that had a limited field of view ahead as a result of a crest of a hill of approximately 100 metres. The defendant was executing the right turn, and as he was in the process of executing the right turn, the oncoming motorcycle at speed, travelling 80 and a 60, came over the crest of that hill and towards the defendant. The time within which that motorcyclist was in view, as in our case, was approximately, or on the judge's finding, would have been approximately 3 seconds. It was 3 seconds, as the judge found here. It was against that backdrop that it was alleged against the defendant that he was negligent in continuing his manoeuvre into the side road, and that he should have stopped immediately to allow the motorcycle coming towards him to have an opportunity to pass.
In front of him?
Yes. Oh, well, he was already out into his manoeuvre and turning across the right into the side road. He was already embarked in his manoeuvre, and it was the, do I carry on? Do I stop, or is there some other evasive action that he might have taken? We can come to Lambert and Clayton because we rely upon it for the split-second decision and the reality of the situation when we come to causation. But at this stage, could I ask my lords and my lady to read paragraphs 31 and 32, please? They're on page 11.
This is to do with the case where the defendant saw the oncoming driver.
Yes.
And took a decision in the moment.
Yes. But referring, sorry.
How does this apply? Well, in the present case where the car driver didn't see.
Well, it will apply later on when we come to causation, because what you have to consider is what should Mrs. Taylor have done had she seen the car coming from her left. And so the appreciation of the split-second nature of a decision and the challenges that she would have faced are highlighted here, but would have been the same for her. But at this stage, the reason we take you to this passage is it's not negligent, it's not a failure by a reasonable motorist having done the checks to assess that it's safe to pull out and create to enter the road to create an obstruction for an oncoming vehicle from the left. When she looked and made her assessments, as the judge found, it was reasonable and safe for her to pull out. Anticipating the sort of speed that was reasonably foreseeable, somebody at the speed limit or slightly over the speed limit, executing her manoeuvre in those circumstances would have created no hazard or danger for a car travelling at that reasonably foreseeable speed. As the judge found, a vehicle at that speed, if it had needed to, could have come to a complete stop within no more than 35 metres, even allowing for the longest perception reaction time.
Final sentence of paragraph 31 does, at least, if not limit, does recognise the parameters of this particular case, does it not?
Well, in my submission, my lady, it says, particularly in those circumstances, but in our submission, as a matter of generality, it's not negligent for an emerging motorist to cause another driver the inconvenience of having to slow down. I don't think.
I mean, that's as high as it goes. That's as far as it goes.
Yes, but
Says it's not necessarily
Yeah.
negligent.
No.
The facts, I mean, I may have misunderstood the facts of this case. The defendant in the case was driving his agricultural vehicle and
Yes.
trailer, wanted to turn right into a side turning of some sort, started his manoeuvre, and then along comes the motorcycle at 80 miles an hour, and he's got, do I stop or do I try and make the turn? What's the best thing to do? And he tried to make the turn and disaster happened.
yes.
And rather like my lord, I'm not quite sure where the facts of this really help us very much.
But it's not the facts of it that we take you to it for. At this stage, it's the point that on what we say in terms of a reasonably foreseeable speed, all that, having made her checks right, left, right, and pulled out, all that Mrs. Taylor was going to present to traffic coming round the bend was the possibility of having to slow down, just to drop in behind. As the judge found, it wasn't a situation in which somebody doing at or slightly above the speed limit would have been confronted with the need for emergency braking. All they would have had to do is back off their speed slightly to allow her to get up to speed in that lane and to carry on.
But that's not the nature of the evidence here. The nature of the evidence here is that because of the positions of the two vehicles on the road, there was no opportunity at all for the defendant to slow down. I mean,
Well, the what? Sorry.
Well, in the view taken by the lay witnesses was that they came together, as it were, almost at the same time. That he kept coming, as it were.
Well, no, but sorry, no, that's not the facts that the judge found, and that's not what they.
All right. Well,
described. Sorry.
I mean, you're talking about a scenario in which a person turns into your carriageway, the carriageway that you're proceeding along, the main road in our case, and that they're in that carriageway for long enough that you could slow down and avoid the accident. I mean, the point that's being made here is that you don't always have to avoid inconveniencing other motorists by causing them to slow down, particularly slowing down, I imagine, to the speed limit or under the speed limit, and that you shouldn't simply say because an accident's happened that therefore somebody must be at fault.
Yes.
For it. So how does that slowing down fit in with the facts of the particular case here?
Because on the facts of this case here, in terms of what was reasonably required of Mrs. Taylor, and it's linked to the reasonable foreseeability point, for traffic coming around that bend, and it may help because we've looked at Mrs. Taylor's view, but in terms of the road layout for the approaching motorist, can I take you to the supplemental bundle at page 108, please?
Have we finished with Lambert and Clayton for the moment?
Well, for the moment, yes.
Thank you. Supplemental bundle page.
Supplemental bundle, page 108.
Yes.
So in terms of visibility on this road, and both Mr. Raspin and Mrs. Taylor both know the area well, what you have here is the view of the approaching motorcyclist. So for Mr. Raspin coming around the bend, this is that sweeping right bend. If my lord and my lady, look to the right-hand side, the third car back, we start with a silver vehicle with its headlights on, a red vehicle behind that, and then do you see the third that looks like those small
Well, we can
vans?
see the hatchings, can't we?
Well, exactly, my lord. You've got the hatchings immediately in front of it, and that's the junction for Hardwick Court. In terms of an understanding and an appreciation of this road layout and what was required of Mrs. Taylor, as she's at the end of the junction, and from the moment she starts pulling out, she is there plainly in view. We're at 80 metres here. This is 80 metres from the point of impact, and we have the range of visibility for the approaching motorcyclist. This is not he's confronted. I think my learned friend refers to a blind bend somewhere. But the visibility for traffic on the main road, and in terms of what Mrs. Taylor should anticipate, traffic coming here has an early view of her pulling out from the side of the road. in terms of anticipating what's reasonably foreseeable from that traffic, at or slightly above the speed limit in the 30s, there is, as we see here, at least 80 metres, probably more, over which those vehicles simply just slow down to allow Mrs. Taylor to execute her manoeuvre. At worst, by pulling out, looking right, left, right, and then executing the manoeuvre, all that she'll do is present an inconvenience to them rather than a danger or a hazard. And so in those circumstances, to say that she is under a duty to look left once again, where for the oncoming traffic there's such a large field of view to see her, in my submission goes too far. Because at most, in terms of the consequence of not looking left a second time, at most, for what's reasonably foreseeable, that's all that she's going to present, is a reason to slow down slightly for a car that suddenly comes round the bend, a vehicle, after she's made her checks and pulled out. Point number 6, then we'll finish with ground 1. I think I'm at point number 6, my lord.
Yes.
It's gap acceptance
Yes.
theory. This was the evidence of Dr. Walsh, or to remind you, the judge dealt with this at paragraph 98. In fact, it might be worth going back to paragraph 47, please, page 75, in which the judge, 47 and 48, explains what gap acceptance theory is, or evidence is, and then at 49 explains its relevance in this case.
Yes.
And Dr. Walsh's evidence on gap acceptance, as the judge observed, was drawn from real-world observations, and the judge found that and accepted Dr. Walsh's evidence that approximately 50% of drivers, average drivers in the normal population, would regard a time gap of 5 to 6 seconds as a reasonable gap, a safe and suitable gap within which to execute their manoeuvre. The manoeuvre being the manoeuvre that Mrs. Taylor was undertaking. For your note, this is the judge's para 98. What follows from that is that, and we have the judge's finding, that to the point of impact, so out into the lane, was approximately 5 seconds. 50% of motorists would consider that to be a safe and suitable gap to pull out into, but the judge has found that, in effect, not 50%, but no percentage, no reasonable driver in the circumstances would be satisfied that that was a safe gap and would need to check left again as they were part way through their manoeuvre. In our submission, if the judge accepts, as he did, the evidence as to gap acceptance, and that the near majority of motorists would consider this gap, the distance allowed, approximately 5 seconds for the vehicle to pull out with a flow of traffic at or about the speed limit. If that was a gap that 50% of motorists would consider to be safe and suitable, in our submission, the finding that no reasonable motorist would be so satisfied without checking left again part way through the right turn doesn't sit with what the evidence the judge accepted as to gap acceptance. Because a significant proportion of motorists, as Dr. Welch explained and the judge accepted, would consider that of itself to be a safe gap, not needing any additional or alternative step to be taken. But I think those are our 6 points on
Thank you very much.
ground 1. Is there anything else on those points that I need to look at?
No, thank you.
Grateful. Can I then take grounds 2 and 3 together, please? This is the issue of causation. In our submission, the judge failed to consider the issue of causation appropriately and erred in his finding that causation was made out on the basis of the claimant's secondary case. We adopt as our starting point the observations of Lord Justice Stuart Smith at the permission stage, which provide a helpful and unsurprisingly punchy analysis of the critical questions that the judge that needed to be considered and we say answered. Can I take the Lords and my Lady to page 109 in the core bundle, please? We say this is a starting point because there are other points that we develop. But if we look at paragraph 3, the judge outlines the critical essential findings of fact, all of which are correct. And then at 4, the critical questions therefore seems to me to be A, where D was when C first came into her view, B, how long a reasonably careful driver would or should have taken to realise that C was coming and was coming at speed, and to apply her brakes in order to stop, give way, assuming that that was what she should have done, and see where her car would have ended up had she reacted with reasonable care in the light of A and B. None of those points were addressed at all by the judge in the course of his judgment. If we start with the first, where was the defendant when the claimant first came into view, can I take you to paragraph 102 in the judgment, please? So at 102, and we've looked at this before, so it probably doesn't need a complete reread. This was the passage with the 3 seconds and how far a vehicle, how long a vehicle takes to cover 71 metres at 52 miles an hour. There's no reference at all, consideration or finding as to where the defendant's car would in fact have been at this notional 2-second point, or whatever that point is, to take my Lord's point of if you'd made your observation at a point where it could have provided relevant information, where was the first defendant's car at that point? The judge doesn't consider it, doesn't address it, and certainly doesn't make a finding in relation to it. That is of importance because it's from that point, that's physically the point that the first defendant has reached when she is said to look to her left. The time it takes her to assess the speed of Mr. Raspin's vehicle can only start at that point. Her perception reaction time can only start at that point. And over both of those periods, whether you align them to be 1 or consider them as 2, the vehicle continues to move forwards on its trajectory out in towards the outside lane. There was never any suggestion, and the evidence doesn't support a finding that the vehicle could possibly stop instantaneously with that glance left. There has to be, as Lord Justice Stuart Smith emphasised and we pursue, what's the time frame to actually work out that Mr. Raspin is coming at speed rather than at the normal speed limit. Then to take a decision to respond, then to brake, and as the experts described, there's a delay in the impact of emergency braking, and then there is the how long does it take in terms of distance to come to a stop from there. Without this first finding, none of that analysis, essential analysis, can be undertaken. So the starting point isn't there for a finding or a conclusion that the accident could have been avoided. The judge makes no finding as to where the first defendant's vehicle was at this starting point. Lord Justice Stuart Smith's second critical question, his B, how long would or should it have taken a reasonably careful driver to realise that the claimant was coming at speed? In our submission, and this resonates with Lambert and Clayton, but of itself, to simply see Mr. Raspin's motorcycle in view of itself wouldn't trigger a duty to apply emergency braking. It's only if the perception was that he was travelling at an abnormally high speed, at the speed or close to the speed that he was, could there ever be any contemplation of applying emergency braking? If the perception of Mrs. Taylor was, as it was for all of the other factual witnesses, that Mr. Raspin appeared to be travelling at a normal speed, then there would have been no reason for her and certainly no duty upon her to apply emergency braking then.
Or we'd be in a Lambert situation.
We would be in a Lambert situation.
The whole crux of this seems to me that we're not in a Lambert situation. Because she didn't see.
No, but the reason we're looking at this, my lord, is when you come to, if you're against us on ground one and you found there was a duty to look left a second time, had she looked left at that second time, what you have to consider is what action should she have taken exercising reasonable care at that point. In order to make findings upon that, we have to consider what information would she have had, not with the benefit of hindsight, but at the time. The essential piece of
what action should she have taken?
what action should she have taken?
Yes.
Anyhow. But in terms of that, that's a question of what would a reasonable driver in the circumstances that she was faced with have done. The Lambert and Clayton point is that this was a split second. On the judge's findings, this is at 2 seconds into her manoeuvre. She's 3 seconds from impact. She doesn't have the luxury, and the claimant doesn't have the luxury of Mrs. Taylor having until second 4 to 5 to take avoiding action. If she assesses the need for emergency braking at that point, the collision was inevitable. There's nothing that she could have done to avoid it. The same applies if she reaches that conclusion at some point between seconds 3 and 4. There simply wouldn't be an opportunity with perception reaction time for her to assess and execute emergency braking such as she could have come to a stop. Her opportunity to make a decision as to what the circumstances required her to do at the time was limited to that window, second 2 to second 3. It was a split-second decision based upon a split-second assessment that she had to make. The evidence that the judge accepted, well, sorry, the judge found that the factual witnesses, the Mr. Ward and his mother in the first car, she being the passenger, he the driver, their evidence was that the claimant was travelling at a normal speed, at or about the speed limit, certainly not the speed that the judge found it to be. I think that the driver behind, who probably had an inferior view, had described, I think, the claimant as tootling along. On any view, the impression of those factual witnesses who had a better view and an obstructive view, and in the case of Mrs. Ward, had no competing distractions, she wasn't driving, was that the claimant's speed as he came round and came into view appeared to be, quotes, a normal speed at or about the speed limit. The judge made no finding that Mrs. Taylor would have been in a superior position or would have had a superior opportunity to make an assessment of Mr. Raspin's speed. It's arguable that she was in a worse position because she's got traffic coming from her right, she's executing her manoeuvre, and as she's pulling out to her right, her field of view is narrowing, she's looking more over her left shoulder as she pulls out.
But she didn't even see the traffic from the right.
Agreed. But in terms of her manoeuvre, if she'd looked left at that point, she has second 2 to 3 to try and identify what speed Mr. Raspin is travelling at. In our submission, her assessment can't be any better than the others who were watching the scene and had far better vantage point and no distractions, and they all concluded that he was travelling at the speed limit. if that's the assessment she would have made, there would have been no duty and no requirement, and she wouldn't have applied emergency braking. It wouldn't have been necessary for her to do so.
At some stage, don't hold you up, but it's been over an hour that you've been making your presentation, and this is the first reference that we've come to the eyewitnesses.
Yes.
In this case, and you use them for a particular purpose. But the gist of the eyewitnesses' evidence was that they were troubled by the defendant's driving. They were struck by, from their point of view, her continuing when they couldn't believe that she was going to go on going forward. And it's not suggested that they had a view that she couldn't have had. She was as capable as any other driver of looking to the left however many times. So, I mean, at some stage you're going to have to deal with the that evidence, the evidence of the onlookers.
But the evidence of the onlookers was, first of all, in terms of her continuing with her manoeuvre and pulling out, in those first few seconds, there's no duty on her to look towards her left. So that she if the motorcyclists come round into their view and she's pulling out, on the judge's findings on the primary case, having made reasonable and accurate assessment that it was clear to pull out, that she continues to advance in that phase, can't be criticised. And then that then leaves us, there's a window of 3 seconds, and they all say, we can take you to the evidence, but that they had, for one witness it was 1 to 2 seconds, for another witness it was 2 to 3 seconds to see what was happening. That was the time shot that they had, because what they all described was, they don't see the motorcycle come into view, they don't see the motorcycle at all until after Mrs. Taylor has started her manoeuvre. And if she's already started her manoeuvre, that 5-second window is closing, and they have 2 to 3 seconds at most. But one witness says it was probably 1 to 2 seconds that he had to make an assessment. In terms of those witnesses being surprised that Mrs. Raspin continued to come out, if we're looking in this hypothetical, in this but-for scenario, they're making no allowance for the time it takes for her to assess.
No, but one can break all these things down into small parts, but people who drive on the road, as it were, have a sense of a situation, which a court is entitled to have regard to. It's the court's decision, not the witness's decision. But if one's unfortunate enough to witness an accident, then one has a sense of why this happened. It may be right, it may be wrong, but these witnesses who had a fair view of what was going on had a sense of it.
But we know their sense.
They didn't say, I couldn't believe it, that this lady was turning to the main carriageway and the motorcycle just came along and absolutely ploughed into her. Couldn't understand what he was doing. But their sense was completely different.
But we know their sense of what was happening was mistaken in terms of their assessment of speed. We know their perception of speed and distance on that regard, as the judge found, and there's no challenge to this. He found that they were mistaken, that they significantly underestimated the speed of Mr. Raspin. So if they significantly underestimated his speed, when they're assimilating in 2 to 3 seconds, what can only be no more than an instinctive or gut feel as to whether this accident was avoidable, it has to be seen, we say, in that way. That on the judge's findings, they made a significant error, and we don't criticise them for it. It's a reflection, as the judge found, of the challenges with looming threshold, with their distance, with everything happening so quickly that they were mistaken about speed. And so in our submission, their sense of was the accident avoidable? None of the witnesses from my recollection, and we can go to the transcripts, ever said that they thought it was avoidable. They expressed surprise that the Mrs. Taylor or the Ford car continued coming, but they weren't in a position to express a view in our submission as to whether this was an avoidable accident. One, that would be opinion. It wouldn't be their factual evidence as to what they saw. But second of all, not trying to break it down into the minutiae, but those witnesses don't make allowance for, as the judge must, the challenge faced by Mrs. Taylor had she looked left again at that point. She's got that second to make an assessment of speed to decide what to do. Could she have possibly stopped by the immediate application of emergency braking? That could well be the case. That could well be the view that those lay witnesses formed. But that, they made no allowance, there could be no suggestion that they did, for example, for perception reaction time. That's just the instinctive response or inference from what they saw in the very limited circumstances that they did. What we have to focus on, and what the judge didn't focus on, is actually for Mrs. Taylor, had she looked to her left again, partway through her manoeuvre, as in Lambert and Clayton, it's not enough to simply see the vehicle. There has to be an appreciation of Mr. Raspin's speed. And if you don't get to that speed, why would it be that she was under a duty to apply emergency braking and come to a stop, to obstruct the lane for traffic potentially coming from the right, where her perception was, or would have been, that this was a vehicle travelling at or about the speed limit, which at worst would slow down or need to slow down as she completed her manoeuvre. And in terms of the factual witness evidence, it wasn't, the judge had that before him and doesn't base any of his conclusions anywhere that it was on the basis of what the factual witnesses say, for example, in contrast to any of the expert evidence, that he reaches the conclusion this accident could and should have been avoided.
And that may be a cause for concern.
Yes.
They being primary witnesses of fact.
Well, but they being primary witnesses of fact, my lady, in terms of how the judge approached that exercise of balancing and weighing their evidence in the light of the expert evidence, in my submission, the judge dealt with that perfectly properly. So if I take you, for example, if we look at paragraph 86, please. It was obvious from the judge's analysis and his approach to the evidence that he was well aware of expert evidence not being determinative, of it not being the only evidence, and for it being looked at alongside the factual evidence. So at 86, he says, it follows that to the extent that accident reconstruction evidence can properly help, he was well aware of the context and the value or weight that could be attached to accident reconstruction evidence. At 87, I am mindful, though, that the expert evidence is merely one part of the evidence and turn to the lay evidence. So he was completely alive to, it's not what does the expert evidence say, and simply aligning the witnesses with that, and if not, rejecting it. At paragraph 93, please. This is where, and I think part of Malone and Friends' argument is, that it's for the role of the expert evidence. One role of the expert evidence is as a check and balance on the reliability or accuracy of the factual witness evidence. And at 93, core bundle, page 93, as to the lay witness impression of speed at which the claimant was riding, I acknowledge that none of them thought he was going faster than the speed limit. Their evidence on the claimant's speed is incompatible not only with that of Dr. Walsh, but with that of Mr. Taylor also. To accept the evidence of the lay witnesses on this aspect would mean that the two experts, approaching the matter, as I have said, from very different backgrounds, were radically wrong in their conclusions. Whilst that might be the case, it's not a conclusion I would likely reach. So he is there expressly reviewing and analysing the factual witness evidence in light of what the reconstruction experts say, and again, we can take you to it, but Mr. Taylor's position moved in cross-examination, whereas previously he said the claimant's speed was 29, no more of 33 to 37. Once he factored in elements that he hadn't previously considered, his range of speed was north of 40 miles an hour and up to, I think, 49 or 50 miles an hour, very close to Dr. Walsh's. So in our submission, the judge is very aware of the need to balance the reconstruction evidence with the factual evidence, to view the factual evidence in the light of that and vice versa. And he makes reasoned findings here that whatever my learned friend says aren't challenged. So that's how we respond to your point in terms, my lady, in terms of the judge's rejection of the lay witness evidence as to speed was on the basis of a proper analysis, fully reasoned, and a conclusion he was entitled to reach that isn't challenged. That then informs the extent to which their evidence was of value or significant in terms of their immediate sense of they couldn't understand why Mrs. Taylor kept coming forward out into the road.
He placed some weight on that, as according with the expert evidence.
Sorry, my lord.
He placed some weight on that as according, as he put it, with the expert evidence, end of 102. But he didn't. He preferred the expert view of the precise speed to the lay view of the precise speed, but he sustained his conclusion with reference to both.
Well, no, he sustained his conclusion as to Mr. Raspin being in view. Paragraph 102 is an analysis of where was the claimant, or where would the claimant's vehicle have been had Mrs. Taylor looked to her left at 2 seconds. So that fortification, as you identify, first of all, that's a demonstration, we say, of the judge being on the right track, the need to marry together and look together at reconstruction and factual evidence. But it's not on his conclusion that the accident would have been avoided. It's on the question of where would Mr. Raspin's vehicle have been in view had the claimant looked left 2 or 3 seconds out into her manoeuvre. And that the expert evidence as to time and distance marries with the witnesses who say, yes, as she was in the process of pulling out, the motorcycle was in view, is absolutely right. But that's not what he bases his finding that the accident would have been avoided upon. In fact, in our submission, insofar as he draws from the factual evidence to reach findings, he identifies it there. And the only finding that it supports for him is their view that the claimant was in view as Mrs. Raspin was in the process of executing her manoeuvre. And so, in our submission, the judge has to make a finding as to how long it would have taken Mrs. Taylor to identify that the claimant was travelling at speed and that it was a speed that required immediate emergency braking. That has to have a time frame, and if we're already 2, as much as 3 seconds out into the manoeuvre, in our submission there's no opportunity for her there, when one allows for that. She wouldn't in that split second have been able to make that assessment. And because the judge, we touched on it before, there is no finding as to that time scale, and then it follows there's no finding as to when she would have commenced emergency braking, there's no finding as to where her vehicle would have ended up. All of those are essential findings. It's clear when the judge refers to those phenomena being unknown. I think in the refusal of permission to appeal, he said, one cannot know D1's reaction time nor the effectiveness of her braking response, at page 107. On that basis, it was simply not possible. There was neither the evidence nor the finding that could justify the conclusion that this accident would have been avoided. Because our point about perception, reaction time and stopping distance, all of these were raised with the judge. We made a written application for permission to appeal, effectively mirroring perhaps in a less sophisticated state than we have them before this court. But the points were all there. It was an opportunity for him to address the absence of a finding about reaction time, assessment of speed and stopping distance. But he says here, on the totality of the evidence he had, he said that's not a finding he was able to make. And on that, in terms of the absence of evidence, the claimant led no evidence as to what those times would have been or what those stopping distances would have been. From Mr. Taylor, the claimant's accident reconstruction expert, there was no evidence from him at all addressing the claimant's secondary case. That was in his written report, in the joint statement, and in his oral evidence. So by way of illustration, can I take my lords and my lady to his long primary report, supplemental bundle, page 152, please. His conclusion section is at section 12, starting at 12.1 on 152. If one reads all, we don't need to do it now and I'll be corrected if I'm wrong, there is no analysis there at all of, well, what would have happened if the claimant was out of sight when Mrs. Taylor commenced her manoeuvre in the claimant's secondary case. We can see, for example, it's at paragraph 12.7 on 153, his view about the speed at that stage, a range of 33 to 37 miles an hour. And at 12.10, 154, I'm of the opinion that the Yamaha must have been within the range of visibility afforded to the driver of the Ford car emerging from Hardwick Court for almost 3 seconds before the car commenced to emerge into Appellants Road if the Yamaha was travelling at 37 miles an hour and 3.5 seconds at 33 miles per hour. There's no analysis by him there in the joint statement, in his oral evidence in chief or in cross-examination as to, well, had Mrs. Taylor looked left at some point during her manoeuvre and allowing for a reasonable perception reaction time and a stopping distance and so on, how would this accident have been avoided? The judge was given, it may well be that that's why one may have some sympathy with the absence of findings. It says he was not provided with the evidence. It was a matter for the claimant bearing the burden of proof on causation to reach a finding that this accident would have been avoided. In that regard, it was never put to Mrs. Taylor when she should have looked left, and it was never put to her that had she looked left and seen a motorcycle, she would have applied emergency braking, that's what she would or should have done in the circumstances of the accident.
So you're not saying it wasn't put to her that she should have looked left, it wasn't put to her when she should have looked.
No, it wasn't put to her that she should have looked left. It was never put to her. We can go to the transcripts of her evidence. It was never put to her that during the course of her manoeuvre, she should have looked left for a second time. For your note, in supplemental bundle at 226, there's the transcript of Mrs. Taylor's evidence. The introductions, the oath, the confirmation of her statement are at 226 to 227, and then at 228 we start with the cross-examination by Mr. Brown.
Yes.
So, and no submissions were made as to when she should have looked left or what impact that would have had upon the sequence of events. Probably reflected in the lack of evidence to support it. We don't have a transcript of the submissions, but the judge summarised the competing positions, the competing submissions made by my learned friend and I, and he summarised, I think my learned friend on causation is that the summary is at para 60 in the judgment, page 79.
You're going to have to give me the reference again, I'm sorry.
Sorry, my lord.
The witness's evidence.
The witness's evidence.
No, I was just, as you'd taken us to it, I was just looking at it, but now you're looking at the submissions.
Yes, it was. We don't have a transcript of the submissions to keep the paperwork down. The judge summarised the submissions for the claimant on the issue of causation at para 60 or bundle 79.
Got you, thank you. Well, I suppose, what does one make of the one look to the left which the defendant made was not enough?
Oh, sorry, this wasn't whether my learned friend had argued his case in submissions in terms of they were pursuing the secondary case. There was no analysis given to the judge because there was no evidence that could support it as to how this accident would have been avoided had she looked to her left partway through the manoeuvre.
But how is one to expect that? I mean, from what one sees of the cross-examination of the defendant, was that it established the fact that she didn't see anybody on the road at all. And having reached that point, what more is the cross-examiner to do?
Well, to cross-examine on the second, well...
I mean, there's no point in saying to Mrs. Taylor, well, you should have seen them there because they were there, and you should have done this had you seen them, and so forth. That's not the purpose of...
Well, to put to her what she
of
would
witness evidence, is it?
To put to her what she would have done or should have done.
Had she seen them?
Had she seen? Well, it's seen the car, the Mr. Raspin. It's
That's
had
right.
she seen partway through her manoeuvre.
But she's emphatic in her evidence that that she didn't see anybody.
The first
So-
sorry,
please.
no, the first she was aware of was when literally the accident happened.
Agreed, and that's always been a concession. But in terms of analysing what she should have done, this is on the had she looked left
I
again.
know, but I mean, what I'm just following through because I'm anxious to follow your argument carefully. Is you're saying it wasn't even put to her that she should have stopped here and should have done that and thought that and should have ended up there and this would have then happened and so
Well, no,
forth. But, I mean, what's the purpose of that with a witness who just says, well, I saw nothing.
Well, the purpose of it would be one of the issues is what would she or should she have done had she seen Mr. Raspin's vehicle
Yes, but
approaching from her left?
I understand that that's a matter that needs to be argued out,
Yes.
but I'm struggling to see what help she can be about it.
Well, if it was put to her, she could give her evidence as to what she would have done.
Well, that's right, but it doesn't seem to me to be in any way an essential part of a negligence claim. If somebody says, well, I simply didn't see something, that's their evidence, make of it what you will. But you don't have to start exploring hypotheticals with witnesses in order to make good your case.
Well,
Sure.
when that hypothetical is what would have happened in this scenario, to put to the driver who's the one emerging from the road that she should have stopped to give her an opportunity to respond to that. She could give evidence as to, well, no, I would have carried on with my manoeuvre. She knew this area well.
You then went on to re-examine her. I haven't read that, but you re-examined her. Or you could have said to counsel who was cross-examining her, well, you're going to have to put your case on that. I mean, it just strikes me that I'm having difficulty grappling with your submission where the witness leaves the witness box and you say she wasn't asked about something that's now important.
Well, I can't.
If it was important that she should have had that opportunity to deal with it, then the opportunity was there.
Well, I can't re-examine on something that wasn't cross-examined.
No, but you can certainly say to the judge that this is not right. We need to have this bottomed out.
Well, it's a matter for the claimants as to how the claimants' team pursue their case and how they put it.
Okay, so that's where we get to.
I don't think this is your strongest point.
Very good, I'll move on. Critical question C then, from Lord Justice Stuart Smith, is where did the vehicle end up? And it builds upon what we've covered so far, doesn't it? It is this sequence of findings to reach a conclusion that the accident would have been avoided. And it's another finding that isn't there. The final point here on grounds 2 and 3 is it's the Lambert and Clayton point, that in terms of the agony of the moment presented to a motorist here who's in the process of pulling out. On any view, she was presented with what she would have been presented with a split-second decision. It's not a decision that could or would have been informed by everything that we now know. It was the circumstances presenting them to her at the time, in particular based upon her instinctive assessment of speed, and we've already covered that. What reaction would she have had? It's only if you can reach the conclusion that she should, that the reasonable motorist in her shoes would have applied emergency braking, does the faint possibility of avoiding the accident arise. The judge didn't acknowledge or view the issue of causation in that context. He made no allowance at all for this being a split-second decision in fast-moving circumstances. Can we take you to his refusal of permission to appeal, please, at 107? When seeking permission to appeal from the judge, we made the point that this was a split-second decision for her and was not to be judged with the sort of niceties that we had in a courtroom in Leeds over 3 days. And at bullet point number 1, given the road layout, D1 needed to have looked a second time in order to detect a road user travelling much nearer the speed limit than C was. Just pausing there, that aligns with our interpretation of the judge's finding on reasonable foreseeability. The first defendant needed to have looked a second time in order to detect a road user travelling much nearer to the speed limit than C was. Not that she should have looked to the left to anticipate the possibility of a motorist travelling in the low 50s, but she did not. The breach of duty does not rest on C's speed. The remarks from Lambert and Clayton concern a split-second decision. That was not what was involved here, and such cases are fact-sensitive. When we're looking at what the claimant should have done, had she looked to her left at the time, the hypothetical scenario, the judge he makes it clear, he doesn't even acknowledge that that's a split-second decision for her. And without acknowledging that, any conclusion that the accident would have been avoided in our submission is fundamentally flawed. It makes no allowance for the challenge of assessing speed, the Lambert and Clayton point. That couldn't be achieved instantly. And if you, as the judge did, regard this as not a split-second decision, where I won't say leisurely, but a less instinctive reaction, or the driver has the opportunity to make a more considered and less instinctive reaction, then that's a very, very different scenario to what we were looking at and what the judge should have been looking at in this but for. And we can marry that with his judgment. Because in order to get off first base on the judge's causation analysis, can I take you back to paragraph 99 on core bundle page 96, please? sorry, paragraph 100 on the core bundle, page 97. It's the sentence just below the upper ring hole punch. Does my lord and my lady see in the hypothetical situation? In the hypothetical situation with which we are now concerned, so the but for, if when pulling out, the defendant were to have seen the motorcycle heading southbound at speed, emergency braking would have been needed and her stopping distance would be likely to have been much shorter. Those ingredients have to be established, but the judge doesn't make any assessment on a fair basis as to what Mrs. Taylor's opportunity would have been in what was undoubtedly a split-second decision. And where, hopefully, we are on, the court takes the view we may be on stronger ground in terms of our references to Lambert and Clayton. In Lambert and Clayton, the opportunity for the defendant to assess speed of the oncoming motorcycle there was 3.08 seconds. For your note, we can turn it up if you wish, but it's paragraph 17 of the Court of Appeal judgment. That's at page 8 of our authorities bundle. The court quotes from the judge's findings of fact, which were not challenged, and the judge said, the Honda motorcycle was travelling at 80 miles an hour. It came into view 3.086 seconds before the collision. Now the court, in our submission, rightly in that case, identified that really is a split-second opportunity. It's exactly what we have here, and given that impact is at 5 seconds, the judge had to assess what Mrs. Taylor should have done in that context, and we know he didn't, and gave no allowance for that in his approach, because he didn't consider it was a split-second challenge. Additional points on grounds 2 and 3. First of all, the judge never made a finding that Mrs. Taylor would or should in fact have applied emergency braking. In the passage that we've just looked at paragraph 100, he identified that that was what would need to be done, but at no stage does he find that she would or should have applied emergency braking had she seen Mr. Raspin's vehicle. And the second one that doesn't need expansion is just the question of burden of proof. If we have a situation where it's absence of evidence that represented the challenge for the judge in reaching his findings, then it's the claimant who bears the burden of proof on the issue of causation, not the defendant. Is there anything else we can help with in relation to grounds 2 and 3?
No, thank you.
So on grounds 4 then, my learned friend raised the question, well, why is this here, given the correction that was made below? In our submission, it's here because the correction at the court below, my learned friend said, the judge immediately corrected the error. The judge didn't correct the error in his judgment. There was no explanation as to why he had dismissed the counterclaim, having found that the claimant's own excess speed was causative of the accident to a very significant extent.
Does this really take the matter forward?
Well,
it was a very small counterclaim relative to the claim.
It is not. Sorry.
And analytically, it wasn't correctly dealt with the first time, and then it was correctly dealt with. What's it tell us about the issues that we have to decide?
Well, it shows the judge's fundamentally flawed approach to the issue of causation. That he dismissed the counterclaim on the purported basis that it wasn't that the speed wasn't the primary cause, that the primary cause was the defendant's pulling out. In our submission, demonstrates a fundamental misunderstanding of causation as its application in road traffic or any other claim.
Right. So that's the
high point of it, yes. And it was corrected by the consent of the parties having identified the error rather than the judge. But we set it out in the skeleton argument. I suspect it's not something that improves with repetition.
All right.
Is there anything else we can help you with?
No. No, thank you very much indeed. Yes, Mr. Brown.
My Lord, in fairness to the trial judge, learned trial judge below, can I, the court may well have this point, but can I just emphasise what we were actually arguing about at trial, and why, when there's criticism as to the lack of analytical detail as to the points on causation, first of all, that he did deal with the evidence he had, and he came to the right conclusion. But what the trial was about was that the claimant's pleaded case, as you will have seen, was quite simply the first defendant failed to observe the motorcycle at any point until she realised what had happened at the collision. And you may have picked up from the submission some 3 months, because the trial was adjourned and we were prepping for the first trial before the adjournment, Heaton and Herzog have been served on my opponent on the basis of not that there's a duty to look to the right, continuing duty to look to the right, but the Court of Appeal has established if you're crossing a thoroughfare where there are hazards or other traffic, there is a continuing duty as you emerge from that side road into the main road. And that was clearly our case throughout. The defence we were met with, however, was quite contrasting. It's a paragraph 5.4 of the defence, if you'll note page 123, but it quite simply was stating that the motorcycle could not have been seen first when the first defendant came out of the Ackworth Road, but secondly, or as she proceeded to turn right. And indeed, just by way of background, a interim payment was contested on the basis that liability was denied in full because when she performed that manoeuvre, he was not to be seen and was going at such a speed he came upon her, having performed the manoeuvre. Now, that probably explains the plethora of experts, research papers, reports, etc. as to this case, because that was the issue in the case. I, of course, was relying on behalf of the claimant of the lay witness we had, if they were to come up to proof, as to what they saw and what you, my lord, have recited, and I don't need to take you to the evidence. It's the judge has recited the page, paragraphs 14 to 17, and accepted it. My learned friend had to embark upon a process not only of expert evidence as to speed, but also challenging those witnesses as to whether they were actually on the road where they said they were, and this formed a large part of his closing as to, well, actually the black Astra and the white caddy may not have been over the brow of the hill by the time she started pulling out. But at the end of the day, on the central issues in the case, the claimant's case was proven, and along with the claimant's case is our respectful submission, given the lay evidence as to the rather descriptive phase, she just kept on coming, the motorcycle was there to be seen, etc., that she failed to observe to the left and failed to stop. Now, criticism is made about lack of perception time, etc. One paragraph the court has not been referred to in this in the submissions is, I think, paragraph 101. It's at page 97. You've referred to the paragraph before and the paragraph after, but here, paragraph 101, he does refer to an illustrative range of perception response times, and referring to the figures. And third line, where in the course of a 5-second exit, the claimant ought to have looked left again, depends on her perception and response time, which is unknown, was for her to determine, but it seems reasonable to put it, after allowing for that, and in default of any specific time having been put forward, at around 2 seconds into her 5-second exit to the point of collision. So, my lord, he does actually deal with perception response times. The criticism has been made he doesn't, and he applies it to the facts of this case, that she was 2 seconds into her exit and still 3 seconds off the collision. And we say that on the material he had, as to this precise matter, that, and I'm going to take this in summary if I may, because I've made the point in my skeleton, from really when he goes forward as to causation from paragraph 100 onwards, right through to paragraph, the end of paragraph 102, we have an analysis that is fair and reasonable and perfectly permissible for the judge to make as to not only breach of duty and causation having been established. Indeed, he rounds it off at the end of paragraph 102 at page 98. I'm talking about, and I'll let the Lordship read the last 8 to 10 lines, but he's saying even if he'd been riding in 52 miles an hour, what time she would have had. And he concludes with that note of Mrs. Ward, she just kept coming. Now, we say, in summary, and I said I'm going to be short of a learned friend, the way the case developed, it may well have been the causation point came up as something discussed very much at the end. In fact, there was a discussion in closing speeches whether it had been pleaded. And the learned judge found that it was, and after discussion, you'll see in his transcript, Mr. Allen accepted it was an issue in the case. But our respectful submission in a case like this is, it's not a dry run before the High Court judge and then come to this court with far more calculations, far more observations, etc., when the High Court judge had, or Deputy High Court judge, had the material he had to work with, which both parties could place before him for him to come to his decision. And that material, we say, ties in with what we have said about the way these types of cases should be approached. And from Nadella Middleton in 1995, when there was a lockdown on experts, there seems to be a growth in experts again in the road traffic cases. And that's why the words of Mr. Justice Coulson, as he then was, in the Stewart case, we put before the court. I'm not going to go into detail. I know your Lordship's relation have read it. But the fact of the matter is, the prime case for the claimant, as indeed in any case this should be, is the lay evidence before the court. And indeed, when the court summarised our submissions, and you've been given the reference for that, it's exactly how I put the case before His Lordship below. Take the lay evidence first, findings of fact, and then compare that to the expert evidence. Now, the reason for the respondent's notice, where I probably wanted to push the envelope a bit further, was this point about the evidence of the first defendant in cross-examination. Because I put to the court that, on the basis of her evidence, she was insistent, and this started in the police interview 2 hours after the accident, she was insistent that there was no traffic to the right, and insistent there was no traffic to the left. And criticism was made of my approach, but I think page 231 I actually put her not looking and seeing a motorcycle to the left in the transcript. Now, the reason I wanted to deal with that in the court below and in this court was, even if she had looked, I mean, it was my, this was my true secondary case, even if she had looked, her stance that day was she wasn't seeing anything on the road whatsoever. Now, the learned judge dealt with this at paragraph 92. And it's at the bottom of page 92. If I invite the court just to read paragraph 92. Now, he accepted that as my line of argument, but as he states at the end, my conclusions don't rest on this line of reasoning. I laid it again by respondent's notice before this court, that this court could be satisfied that actually in the circumstances of this case, the liability and causation are found. It is an extraordinary case, really, my lords, if I may just say, that a case where the claimant doesn't know anything about the accidents until the collision, classic came out of nowhere defence. The Liverpool Victoria Insurance Company are engaging Dr. Walsh and all the forensic evidence to prove that he was going so fast as to not be seen, whereas the claimant's reliance, and we say the court's reliance, should be upon the lay evidence as to what was visible at the time. That is the approach that these courts, this court certainly directs, and perhaps I'd be so bold to say should direct, as the court below again. So I've dealt in my written submissions at length about that matter. The one point I have to deal with is speed, because it's been raised about speed, that it's 52 constant speed throughout. We say no. It's been dealt with by my learned friend at the outset of his submissions in paragraphs, reference made to paragraphs 94 to 96. Now, we have never read, and if we're wrong, we will accept it, we have never read those passages of the learned judge as being a constant 52 miles an hour, because he had to come round the bend for a start.
Well, that's why I raised the point when Mr. Allen made it.
Yes, indeed. Where the scientific evidence was almost accurate, and I'll deal with how accurate it is with the range, because the point needs to be made, but was at the point of collision, because of the trajectory of the motorcycle, the scrapes in the road, the striking of the curb, etc. That's the most accurate point, and that's where we took the comment about him being at 52 miles an hour immediately preceding the accident. But we say we're right on this, because at paragraph 96, if you go further down, at page 94, at the bottom of the page, he talks at the bottom of the page about a vehicle travelling at 40 miles an hour, covering a distance of 71 metres, or a speed of 50 miles an hour in the penultimate line, covering the distance of 71 metres. Now, if his conclusions were, and I cannot find them directly on what Mr. Allen says, but if his conclusions were early 50s throughout, then why on earth would he start reciting speeds at 40 or speeds at 50? And so we say that it's not a constant speed throughout. We have to accept in his finding, and there's no cross appeal, that it was in the early 50s at the point of collision. And that point, of course, is something I raised in my submissions, that sorry, give me a moment. The speed approaching is going to be it's a range. These figures are not accurate. But the cause of the collision, the primary liability of 55% as found by the judge, was the vehicle moving into the path of the motorcycle. The learned friend's case is actually he is the primary cause of this collision, and therefore there's 0% liability on the car driver. Well, we say that is just not right. We accept the 45% deduction. It was high, but one cannot come to this court and say it wasn't within the range of discretion of the judge on the evidence. But the element of speed is that of contributing negligence, not of primary liability. As to speed, the learned judge did say at I think a number of paragraphs, paragraph 85 particularly, he refers to the range of speed being at the bottom of page 90. He says the approach of Dr. Walsh providing a mean and a standard deviations tantamount to providing a range. That's a paragraph, first line of paragraph 85. And he talks in that last three lines of that paragraph, if you take a 25% point of the range of skidding coefficients that lead to a speed of 40 miles an hour, the 75% result in finding of 64 miles an hour. I just say in passing, because the speed is the one point where the experts were of assistance, is that in his report, throughout his report, there was never any figure given indicated by Dr. Walsh other than 52 to 55 miles an hour. It was only in cross-examination when one went through the range of coefficients and the variables on a scientific analysis of speed that he accepted if it's a lower end of 25, it's 40, the higher end of 75, it could be 64 miles an hour. So, my lords, I'm not going behind the judge's comment that his mean can be a range, but in fact the range was not given in his expert's report. And that's why I took up the matter at trial, and that is why in my cross-appeal skeleton, respondent skeleton, I've actually taken or directed your attention to the rules of court, because it's quite important that the range should be given in such uncertain circumstances. But that probably is going on about a point that is agreed between us, that we are fixed with early 50s at the point of collision. So how does my friend put his case? If I can wrap my submissions up, and I said I'd be much shorter, my lord. The fact of the matter is he cannot argue about such matters as he does of this claimant being hindered by traffic coming from the right and therefore not acting on the motorcycle coming from the left. It is a non sequitur. If her evidence before the court is she saw no traffic to the right, that cannot possibly assist him as he tries to submit that she's put in a difficult situation. And if I can take you to the difficult situation point in the case of Clayton, I can ask you to bring up that judgment. And in passing, my lords, comment, this was never produced in the court below, it's only been produced on appeal. Paragraph 27 is the extract which I wish to draw your attention, if I may, within the judgment of Lady Justice Smith. Because in paragraph 27 it says this: the judge was not critical of Mr. Lambert's driving in any respect other than he made the wrong choice when faced with a split-second decision. And then my lord, the next words, the judge did not hold he had not kept a proper lookout. Well, that's wholly different in this case. There was such an allegation in this case. He did not hold he was not entitled to begin his turn when he did. And then there's this: it's not said that he failed to see the motorcycle as soon as it appeared. And again, there is an allegation here that they did not see the motorcycle, certainly on its route towards the point of collision. So, my lord, you have in discussions with my learned friend engaged with him as to whether Lambert is particularly helpful in this case. For those two reasons alone, in addition, I say this is not the type of case of split-second decision. This is the type of case that didn't occur in Lambert of failing to keep a proper lookout and failed to observe the motorcycle. So in looking at those matters and dealing with his grounds briefly, I mean, ground one is, I note what the Lord Justice giving Leeds said, it may not be there if it wasn't for the other grounds, but the fact of the matter is there is law as to continuing duty, and there is fact of the witness statements of those who saw the accident, and there I put my case on that point. My learned friend on grounds 2 and 3 complains that the questions posed by Lord Justice Stuart Smith haven't been answered. But the counsel complaining about that has considered what evidence was put before the learned judge to answer those questions. And he did, in our respectful submission, not going back to the paragraph, he did look at the time it took. He did decide that 2 seconds in, she should have looked and the motorcycle would have been seen. And he did, the paragraph I've just given you, with regard to perception times, is it 101, he did look at the perception times applicable to this type of case. And therefore, my lord, I submit that the criticism of the learned judge below is in a vacuum as to actually what occurred in the trial below and the material the judge had to work upon. But even so, the material the judge worked upon cannot be better than the lay evidence he saw and the expert evidence giving him the speed of the motorcycle. Lord, I'm not even going to deal with ground 4. It was dealt with by consent as soon as the mistake was realised. But that's how we put our case, and I apologise if it's brief, not dealing with each point by Mr. Allen, but the background of this case...
We're very severe on brief submissions in this court.
Well, that's a relief, and I'll remember it.
No, but unless my lady or my lord have any question for you, I'd just like you to educate me a little bit more about your opening remark about the what happened in the 90s about expert advice in this field and what you say is now happening.
It's Liddell and Middleton.
Right. Can you, because...
It's at first authority in my bundle to this court in July 1995, where they, I've marked the passages both per curiam after the head note and holding. So they refer to the exception that road traffic accident cases exception rather than a rule that expert witnesses are required. And in this particular case, they brought nothing to the table at all. And the passage that was picked up by Lord Justice Coulson when he was a puniary judge dealing with the Stewart case is that on this P42 on the penultimate page, a sideline there, my lord, and in particular on the next page, P43, the penultimate paragraph, we don't have trial by experts in this country, we have trials by the judge.
I'm sorry, I was just catching the... we're in Stewart and we're at...
Oh no, if we go to Stewart...
yes, you were just reading from paragraph...
In Stewart, subsection 2.2, paragraph 8 onwards. In particular...
Yes, right, I've got that.
8 to 10 where it's sidelined. And as Mr. Justice Coulson, as he then was, conclusion, in my judgment, is the primary factual evidence which is of the greatest importance in a case of this kind. The expert evidence comprises a useful way in which that factual evidence and the inferences to be drawn from it can be tested. It's, however, very important to ensure expert evidence not elevated into a fixed framework or formula against which the defendant's actions are then to be rigidly judged with a mathematical precision. Now, of course, since those days, we've moved on to case management, cost management. The judge is should be reviewing whether such expert evidence is reasonable or necessary. So there are some safeguards, but it is more. I suppose it's the size of the claim. The size of the claim, you may expect experts to be looking at this case as my client is paralysed. I'm grateful for this being broadcast so it can be seen, but. In lower cases, it's becoming prevalent, and it's a matter here. Even if it's within this court, the complaint I was making in my respondent submission was there should always be a range given of opinion, not fixed opinions. And
so the complaint here is evidently not that there shouldn't have been any experts, because there was a glaring dispute about speed.
Yes, examination, motorcycles, and speed, and therefore speed is the point which was the fixed point.
So would it be right to understand you as entirely accepting that expert advice was needed on the question of speed, but your residual concern relates to treating expert evidence as being fact rather than opinion?
Yes. And a range of opinions is a range of opinions as well.
Particularly in a case where there were certainly two witnesses and a third who gave evidence as to what they'd seen and the position of vehicles prior to the collision.
Very much so. Lady, there was in the old days of knockabout county court work, the judge may have stopped to the lay witnesses.
Yes, but I do remember the knockabout days of county court work, Mr. Brown.
But yes, I mean, the evidence was there and the judge had to consider it, and we say he considered it appropriately in deciding this case.
Right.
Thank you.
Well, thank you very much indeed. Yes. Do you reply, Mr. Runner?
Only 2 points.
Thank you.
One, this is not an attempt to argue points or that weren't pursued before the judge, or treating that as some sort of shallow dry run, and we're now presenting our real case. The reference for that, para 78 of the judgment at 87. It's not that we're wise after the event and say, oh, well, with hindsight, you haven't looked at this. Paragraph 78, the judge summarises, obviously, as you've seen, my submissions have been more detailed than the one paragraph, that captures the headlines of them there. If the judge was against us on causation, on duty causation had to be established. It had to be established that the accident would have been avoided. We have the putting it to the defendant point. And then no one, headlines of questions we raised. No one could say where the claimant would have been at the point that the defendant looked left. And so to judge whether it says he could have stopped, that should obviously be she should have stopped, because it refers to the defendant. Had the defendant looked again? Mr. Allen characterises the high point of the evidence on this issue, the view of Mrs. Ward. If the defendant had stopped, the collision could have been avoided, but that does not take into account perception and response time and braking distance. So we raised the questions, all of the questions that we've now identified on review of the judgment for the judge to consider, but he didn't. Point number 2, it takes us back to my lady's point about the constant speed, and my learned friend addressed you on that. One paragraph of note is paragraph 83, because there was evidence given by Mr. Taylor, the claimant's expert. I think, well, because of the bend, that couldn't be negotiated at 50 miles an hour, and that was based upon he'd driven the bend in an automatic Volvo diesel. He had experience of this sort of motorcycle. His view was you would struggle to round the bend at that speed. And that was raised, and that was part of the claimant's case. And at paragraph 83, the judge dealt with the evidence of Mr. Taylor, suggesting that it wouldn't have been possible to round the bend at the speed that we say, went on to find. He says, the claimant does rely on Mr. Taylor's evidence that it would not be possible to ride the sweeping bend at 52 miles an hour. This is core bundle, page 89. However, I place minimal weight on that. It was introduced very late indeed. The claimant himself, in his statement to the police, had not sought to rely upon the impossibility of rounding the bend at such a speed. Mr. Taylor had not made the point in any of his previous reports. I reject the suggestion it was made to counter an indication in the joint statement by Dr. Walsh referring to the CCTV footage. The footage had been raised by him as early as in his report in May 2020. Whilst I do not regard the evidence on the safe riding of the bend to be inadmissible, another reason for placing minimal weight on it is its lack of scientific rigour, being based on an assertion but not backed up by tests other than having driven the bend in a car. So insofar there was any evidence that might suggest that that bend wasn't, or in fact, or couldn't have been taken in the low 50s, the judge attached minimal weight to that, and we say dismiss that suggestion. And so we come back to it was a constant speed in the low 50s. My Lord's reflected the point on the need for expert evidence in this case. I don't think anyone would suggest it wasn't required, nor that it operated within its proper boundaries. There was nothing else for us.
Thank you very much indeed. Thank you, Mr. Allen. Thank you, Mr. Brown, and those who support you. It's obviously an important matter for the parties. We'll take time to consider our judgments and let you have them in draft in the normal way as soon as possible. Would you please, when you've corrected any editorial matters, let us have a draft order that reflects the decision, and we'll hand down in the normal ways nowadays electronically without troubling you for further attendance. If you should happen to disagree about any points, please identify them and we'll decide them on the papers. Thank you all very much indeed.